Well, we've been expecting this one. Hey guys, this is Jules with True Crime Reactions. Disclaimer, everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. So, you guys know that in the last hearing in the Idaho 4 case, Ann Taylor, who is Bryan Kohberger's attorney, told the court this.
Understanding the state's concerns if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, council and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard.
And Bill Thompson, who is the lead prosecution for Idaho, the state, told the court this.
Making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's going to change anything, Judge. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We at least owe Latah County, the people of Latah County, the attempt to seat a jury here first.
Now, he also said this.
The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-rotation. Said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
So I'm wondering now, since this document is now out here in public, if he's going to get his way or if the trial is going to end up somewhere else. And that is if this change of venue is actually approved. Now we're going to go ahead and read the document. There's not really a lot going on here. It's pretty basic. It just states, comes now Bryan C. Kohberger by and through his attorneys and hereby moves this court for a change of venue. By this motion, Bryan requests a jury pool from outside Latah County. This motion is made pursuant to the 5th, 6th, 8th, and 14th Amendments to the U.S. Constitution. And then it goes on to cite some more of the ICR rules. And in this case, it is the Rule 21 and then 19-1801. You know, I'm always going off about the ICR 16-1-8 situation, but they're not citing those in this one. A fair and impartial jury cannot be found in Latah County owing to the extensive, inflammatory pretrial publicity allegations made about Mr. Kohberger to the public by media that will be inadmissible at his trial, the small size of the community, the salacious nature of the alleged crimes, and the severity of the charges Mr. Kohberger faces. Enlarging the jury pool will not do anything to overcome that pervasive prejudicial publicity because Latah County does not have a large enough population center to avoid the bias in the community. Further, the size of the community and the interconnectedness of its citizenry, this is some verbiage, isn't it? Is problematic and will prevent a fair and impartial pool of potential jurors. Mr. Kohberger, by and through his counsel, requests an opportunity to be heard through evidentiary presentation and argument no sooner than the end of April 2024. So it is January 31st. We're about to be in February. They want all of February, all of March, all of April. They're okay with 3 months. They'll wait 3 months, but they want to be heard before the end of April of this year. Now, we knew this was coming, and the whole reason why I felt like the hearing on the 26th was such a waste of time is because they mentioned a change of venue, but then said they weren't ready to argue it, but then started talking about how they needed more time because they wanted it to be in the summer. And that was based on their local stuff going on with parking and hotels and the college schedules and the school schedules, because apparently there's a school really close to the courthouse. It was basically a very redundant hearing. It was literally a waste of money. It was a waste of money. It was a waste of time. It was a waste of resources. It was a waste that literally nothing was accomplished. That entire hearing, like I said in my video about the hearing, there's a lot of things that we kind of heard them say that we can, talk about now. But when it comes to this actually getting on track and going anywhere, it didn't really do much. Okay. So now we have this change of venue, and we know that Bill Thompson made, I know what he was saying was sarcastic. Okay. But there's also other things that have gone on that a lot of people feel are connected to this case that have a lot to do with Nez Perce County, or however you say it. I feel like I'm not saying it right. But there's a lot of things. So I don't know. I don't know. I'm just going to stay away from that for now, and we'll see what happens with it. But again, this also goes to like John Judge having to approve it. So if Judge doesn't approve it, then I don't know the next steps. I guess they'd have to take it to the Supreme Court, right? Because I mean, okay, so I know that I mentioned that I felt like it was crazy that Logson was standing up and basically like asking the court for permission to tell on the court, because that's what it seemed like to me. And to anybody watching it, that's definitely what it seemed like. Like he was legitimately asking permission. But then it was starting to get explained that it's more like a courtesy, that it doesn't really matter what the court says. If they want to file with the Supreme Court, they have every damn right to do so. So it'll be interesting to see what actually does happen here. But I guess the only thing that's really mattering at this point, what everything sort of like is waiting for, is Judge to make a decision on something. Because I know that whenever we had the hearing towards the end, he basically denied everything that was going on, but we haven't had his public final decision come out yet. So a lot of that depends on which way he wants to play this. But I think that if the defense is really serious about going to the Supreme Court, then they already have everything they need together and ready to go. So I really wonder what they're waiting for. Like, obviously, they need to, like, let the courts know, but we know that these are conversations that they're also having in the background. We learned a lot about the way that there's communications actually going on in the backgrounds whenever everything started coming out about what's going on with Delphi. There's a lot of back-end conversations, emails, conversations in private, a lot of stuff that's not on the record. So whenever they have these conversations like this in front of us, it actually kind of shocks me that some of them act surprised. Like, the defense and the state are a lot like on the same page, which is, like I've mentioned before, makes me uncomfortable. But the judge, he's always sort of acting like he's sort of surprised about stuff. Like when it came to the scheduling and them trying to push the scheduling back a lot, he was like hella trying to push it to be rushed and like, oh, you don't need that much time. And I'm like, why are you acting like y'all didn't have this conversation already? Because we know damn well y'all did. You know what I mean? It's just stuff like that. But yeah, anyway, you guys, that's the document. There's really nothing here going on. We're still waiting on a lot. So it's just a big waiting game. Anyways, that's it, you guys. If you like the way that I present this information, please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. See y'all.